Good evening. Welcome to the Pearl Report. I'm Diana Lin. In the 20 years since the handover, Hong Kong saw much socio-economic and political changes. While mainland China flexes its economic muscle, many Hong Kongers feel they're wallowing in the mire and worrying they're losing core values. One country, two legal systems. Which has the right of final adjudication? The clash of the two legal systems stemmed from a verdict.
Margaret is elected.
中华人民共和国香港特别行政区正式成立。
The year 1999 was a momentous year for the development of constitutional jurisprudence.
This government has no sense of the rule of law, and it is doing a lot of harm to Hong Kong.
我得票數為689票。佔領中環，正式啟動。
We had a very good legal system, but at the same time, because the one country, two system is a new concept, we cannot just protect and uphold the original system without accepting the new provisions.
This is the starting point of my first march for democracy just before the handover.
I hereby declare that Margaret is elected.
When the first interpretation came so very soon in 1999, the legal profession was very deeply shocked.
The old French mission. Before the handover, this century-old granite and red brick building was the Court of Final Appeal, the site of the first battle of one country, two systems. The Nga Ling case fought for right of abode for undocumented children in Hong Kong, the first lawsuit of its kind heard by the Court of Final Appeal. The verdict said Hong Kong courts have a duty to examine whether any legislative acts of the National People's Congress or its standing committee are consistent with the Basic Law.
對於最近終審法院個判決，內地認為呢係違反憲法、違反基本法嘅，呢個錯誤呢係應該作出糾正。
Mainland China has a socialist legal system where the National People's Congress has supreme authority and its standing committee has the right to interpret the law, including Hong Kong's Basic Law. But the Basic Law promises common law for Hong Kong with an independent judiciary and final right of adjudication. Under common law, the courts interpret the laws. Under one country, two systems, are these two legal systems fundamentally contradictory? Do Hong Kong courts have the right to vet the NPCSC's actions?
There was still a strong refusal to say that we would give effect to any act of the National People's Congress, even if it is contrary to the Basic Law. The Basic Law was meant to be a document that everybody can understand. The interpretation coming from the Standing Committee actually changed the meaning of the law. And so it is arbitrary out of a need for a particular political consequence.
The Basic Law is our new constitutional order. You have also to accept the new provisions. For example, the power of interpretation is just part of the new system. That clause relates to matters within the authority of the Central People's Government and the relationship between Central People's Government and the Hong Kong SAR. If the Standing Committee do any act in accordance with the Basic Law, then we cannot doubt its validity.
1 month after the judgment, the Court of Final Appeal clarified it cannot challenge the NPCSC's authority, and whenever the NPCSC interprets the law, Hong Kong courts must follow.
It was the darkest day because to us it seems that the court bowed to power by giving a clarification of something which was perfectly clear. There is no need for any clarification except as a token of the court's subjugation to political power.
Margaret Ng tabled a no-confidence motion against Elsie Leung as Secretary of Justice for failing to uphold Hong Kong's judicial independence. Under common law, the power of interpretation belongs to the courts.
呢啲唔係我個人提出嚟嘅憂慮嚟嘅，而係整個法律界好多人提出嚟嘅憂慮，同埋廣大市民提出嚟嘅憂慮。
In mid-1999, Chief Executive Tung Chee-hwa sought the NPCSC's interpretation to overturn the CFA's judgment. More than 600 legal professionals clad in black staged Hong Kong's first ever silent march to the CFA building. In a seminar during the 15th anniversary of the handover, Elsie Leung said the CFA's ruling is a repudiation of sinicization and the country's control.
特區嘅法律界就當然包括法官啦，係對中央同特區嘅關係咧係缺乏認識嘅。點樣睇得出咧？就剛才講吳嘉玲個案件咧，一個地方法院係唔可以宣布全國人民代表大會會同佢常委會所做嘅嘢係無效、違法或者無效而係需要咧係不能，其實係不能質疑。
There is a fundamental difference not only between the different legal systems, but also in the very culture, the very understanding of the rule of law. By the rule of law, we mean that the law is certain and everybody has to obey the law. But what we see across the border is they believe that the law gives those who are in power ways of extending their power. And so what matters is who has the greater power, not what the law says. They do not see the law as restricting the exercise of power.
The NPCSC's interpretation of the Basic Law has been sought 4 more times, pertaining to 5-step political reforms, Chief Executive's term, diplomatic immunity in the Congo case, legislators' oaths. Margaret Ng says the NPCSC does have the right to interpret the Basic Law, but as in the Congo case, the Hong Kong government must request an interpretation, as stated in Article 158, Section 2. That upholds judicial independence.
We have always been very worried about Article 158 of the interpretation power of the Standing Committee. If it is exercised in an arbitrary way, then the Basic Law will become totally meaningless. Because if you say the law means what I say it means, the protection of the Basic Law would be negligible.
Chief Justice Andrew Lee said in a speech after his retirement, the NPCSC's power of interpreting the Basic Law, albeit legitimate, should be exercised with discretion.
The public needs to accept this is part of Hong Kong's legal system. The question is, when to use this power? I feel after years of experience, Hong Kong and Beijing have a consensus the power exists, but should be considered only in very special circumstances.
They thought that probably in the beginning we should be given some leeways to get accustomed to being under Chinese sovereignty. But as a matter of fact, we became very, very far from being controllable, and so they feel that they have to apply a harder approach and put more pressure and tighten up the control over Hong Kong. That is why they become more and more blatant and they become more and more intrusive. The Standing Committee does not exercise the power frequently. It only exercises it sparingly. It would only exercise the power interpretation when it's necessary. And in the past 5 times, it was necessary, and it resolved problems which we ourselves could not resolve.
Unrests and conflicts engulf Hong Kong. Some propose breaking the law to achieve their ideals. How does that affect the rule of law? When we come back, stay with us.
Welcome back to the Pearl Report. The anti-national education siege of government headquarters, the Occupy movement, the Restore Hong Kong campaign, they shout the message, you can use illegal means to attain your ideals. 20 years after the handover, is the rule of law still intact? What other challenges does it face?
Constitutional duty and responsibility on all judges can at times be an onerous one.
Civil disobedience emerged in Hong Kong 3 years ago.
If you violate the law, you have to bear the consequence of it.
Everyone's power or everyone's rights are limited by what the law.
Do you think civil disobedience is actually a challenge to the rule of law?
No, it depends on how we handle it. Actually, civil disobedience protests is very common everywhere in the world. Don't emphasize on the number of challenges which the government has received and how it handled it. We handled it efficiently, sufficiently.
During the 79-day Occupy movement, protesters commandeered roads, buses, and even set up barricades. Does this contravene the rule of law? From the start of Occupy, Margaret Ng gave talks at protest sites to encourage non-violence and sensible discourse. But she thinks the government also had a responsibility to appease the crowds.
Our government seem to have lost any sense of propriety because they have lost moral force in society. Then there seems to be a confusion, a kind of general lawlessness. People feel that they have to resort to self-help, and I think that is very, very unfortunate.
I think it was very well handled because elsewhere it would have caused lives, it would have caused bloodshed and so on. But I think on the whole we did it very well. Political issue through the judicial system. It's just for the court to decide what to do.
During the movement, the court issued injunctions to clear obstacles from the roads. But some scholars called on the protesters to collectively disobey the decrees, saying they are civil injunctions so they wouldn't harm the rule of law. Student leaders also said they wouldn't retreat. The protesters ignored the injunctions and set up barricades to deter clearance. The Hong Kong Bar Association declared such actions eroded the rule of law.
I think it is unfortunate to see this increasing trend to express their dissatisfaction with the rulings of the court. It shows partly some of the people, they really have no respect for the rule of law. They should realize that doing that harms the cause of democracy.
Occupy Central co-founder Benny Tai stressed civil disobedience was a very important legal tradition in common law.
Prosecutors and judges respected. Handling cases on civil disobedience. Judges won't acquit you, but in sentencing will consider such a factor.
Benny Tai thinks breaking the law to win social righteousness and bearing the legal consequences won't harm the rule of law.
You must know what is righteousness. The standard is not just set by a single person. So people have their ideals. People want to make protests, they have full right to do so. But you have to accept the consequence of it, including legal punishment.
At a public event, Elsie Leung spoke of the recent unrest in society and its impact on social order.
紛爭越嚟越多，矛盾激烈，好多人嘅心情係煩躁，甚至有少部分人認為可以用暴力解決問題，好似佔中佔旺，係令人擔憂嘅。
More and more clashes erupted after the Occupy movement. A slew of subsequent lawsuits spawned allegations of political prosecution.
Over the past year or so, I've sometimes received complaints from members of the public. Dissatisfaction is also expressed when the courts have convicted or imposed what are seen to be heavy punishments.
If the court got it wrong, everybody will be able to say it. So that's within the freedom of speech. But to attack, to insult, and to encourage people to attack physically a judge or physically harass his friends and family, that falls into a totally different category.
There may be legal issue amongst political disputes. So you cannot say that just because in more political issue, it cannot be entertained by the court. That's happening in every country, people using legal system to air their grievance. But of course, if they're wrong, then they'll be penalized with force.
The co-location agreements comply with the Basic Law and One Country, Two Systems.
One country, two systems guarantees Hong Kong's judicial independence, but challenges ensued. A proposal for co-location arrangements at West Kowloon's Express Rail Station aroused much controversy.
Co-location means the mainland officials will be sitting in West Kowloon and apply mainland laws and force mainland laws. That would be contrary to Article 18 of the Basic Law. The mainland laws cannot apply in Hong Kong.
I want to state solemnly the provision under the Basic Law, namely only legal enforcement agencies in Hong Kong have the legal authority to enforce laws in Hong Kong.
This is not a legal issue. There's no evidence that anybody from the mainland exercised the power of arrest or taken away anybody from Hong Kong illegally. So I will not comment on any hypothetical question. In Hong Kong, the Basic Law provides the mainland authorities would not exercise their power in Hong Kong.
Causeway Bay Bookshop really shocked our confidence in Hong Kong because even as Li Bo himself said, so long as I obey the laws in Hong Kong and I do not go into the mainland, I should be safe. But what happened to him shows that even if you do this, even if you're in Hong Kong, you can be illegally and forcibly taken back to China and be punished for what you do in Hong Kong because politically is not welcome in China. That destroys the one country, two system and makes Hong Kong unsafe.
She stressed the rule of law applies to everyone, from ordinary citizens to the government. She's writing a book on the rule of law.
Every now and then there would be special issues and I would be writing longer articles. I have a weekly column and most of the time I write about politics and legal issues.
She thinks Hong Kong's rule of law has suffered setbacks in the past 2 decades, and the mainland should understand one country, two systems is to maintain two distinct systems.
Now the people who urge rule of law are the China Liaison Office, the Mr. C.Y. Leung and so on. But they want to promote a sense of rule of law which is really ruled by law, which is the government using the law to control the people. And I think we must counter that. The rule of law is to prevent the arbitrary use of executive power. It is a protection of the rights and liberties of the individual. It is equality before the law.
I think some people feel that the pre-reunification legal system was very good and should be protected by all means. But at the same time, they have not accepted the new provisions in the Basic Law. If there are questions, if there are disputes regarding the law, regarding administration of justice, don't judge us by that, but see how we resolve it. After all, our rule of law is still robust. People still respect the law, respect judiciary. So I don't think it has affected the rule of law at all.
The rule of law calls for respecting and abiding by the law. It also has to uphold human rights. For one country, two systems to work and society to progress, there has to be a mechanism to gather public opinion for better governance. Next week, we'll examine the government's challenges, starting from a plot of land. Well, thanks for watching our show. It will be re-aired on Monday, Tuesday and Saturday, as well as online and on mobile apps. Until next time, from the Pearl Report team, good night, good luck and good health.